Hello, this is our presentation. Click agreements and electronic contracts. We'll focus on states Arizona and California, and this presentation was created by Aden, me, Tommy, and Grayson. So first, we need to understand what electronic contracts are. Since the rise of digital contracts usage globally, the digital contracts are increasingly common as more transactions go online, which highlights need to understand the digital transaction law. Importance of I agree button. By clicking I agree button, it legally binds the user to contract terms, often without them realizing or knowing the full extension of the commitments. Comparing law in Arizona and California. In this presentation, we'll focus on these two states and we'll try to uh, explain and show the difference, the significant difference in their legal approaches, and explore precedents and implication. Our goal is to explain the legal precedents in these states and understanding what it means for both customer and the businesses. So in this slide, we'll look at state laws and electronic contracts within them. So the first state, Arizona, uses Uniform Electronic Transaction Act, which pretty much means that, which pretty much makes every electronic signature or record as valid as paper ones. California, on the other hand, emphasizes on electronic consent validity, and they're focusing on ensuring that customers fully understand and agree to terms before electronic contract is valid. The differences shape the legal framework, which in Arizona and California have different laws affecting the electronic contract and the way they are created. And lastly, unique legal requirements are in both states, since each state has specific requirements for electronic contracts to be valid. It impacts not only consumer but businesses.
My name is Aden DeAguero, and I'll be talking about the Aerocool Corporation versus the state of Arizona. And this goes back to the UETA Act, which was passed in 1989. So, Aerocool Corporation was selling HVAC products and made a contract with the state of Arizona. And basically, the case went to the point where they didn't know if the contract was legally binding. But in the UTA, it states that an electronic signature has the same weight as a paper signature, and the court needed to verify if there was mutual agreement, which there was, and there was clear intent between both parties. And ultimately, this case solidified that Arizona thought that e-signatures were legally binding and established clear guidelines and consent. The next case, which is in California, is the Ruiz v. Moss Bros Auto Group. And Ernesto Ruiz and the auto group had a conflict, and the arbitration agreement was placed against Ruiz. The company had stated that he signed it electronically, but Ruiz claimed he didn't sign anything. So what the court needed to find was evidence that he intended to sign it, and the Moss Bros Auto Group couldn't provide evidence that he did. So there wasn't any way to authenticate that he did sign it. So ultimately, this pushed for companies to verify e-signatures as well as just prove that a signature did take place. So it improved the guidelines.
Right. Hello, this is Grayson Liebhardt. I'm going over the comparison of legal approaches to electronic contracts. So Arizona follows the Uniform Electronic Transaction Act, which grants electronic contracts the same legal status as paper contracts if both parties consent to the use of electronic records and signatures. Arizona recognizes click agreements as binding, given that the user has enough notice of the terms and has a chance to review them. California also follows the UETA, which gives electronic contracts equality to written contracts. However, California does place more emphasis on like conspicuousness. So like the terms have to be presented in a way where like it's reasonable for the person to be able to access them and understand them. And California Consumer Privacy Act affects online transactions by requiring businesses to disclose data collection practices in their terms. So basically, they can't just record data or collect data without the consumer knowing. The impact on businesses and consumers in each of the states, and both states businesses have to make sure electronic agreements are like clearly presented. And yeah, so the CCPA in California adds another layer of responsibility for businesses regarding data privacy. This influences how terms of service are structured. With Arizona, businesses benefit from the consistent application of the UETA, which provides clarity in enforcing electronic contracts. Arizona has less state-specific regulations compared to California, and that gives businesses a little more flexibility. When it comes to consumers, both states, consumers have the benefit of similar protections with the validity of these contracts. California just has a little bit more emphasis with the CCPA as it requires clear disclosures. So in conclusion, electronic contracts are legally binding in Arizona and California. Arizona and California both follow the UETA, which makes sure that electronic signatures are valid. California places additional focus on the visibility of contract terms influenced by the CCPA, which protects consumer data. Arizona is more flexible, but still provides protection under the UETA, so businesses have a little bit more flexibility with Arizona, and these differences shape the way businesses and consumers interact with electronic agreements in each state. So here are references.